Hello and welcome to my channel Happy Hours. In the last video, we discussed about the rights, basic definition of human rights, natural rights, and introduction to fundamental rights, judicial reviews, and some cases related to it. Today, we are going to continue further with more about the fundamental rights, rights to equality, right of equality before law, and equal protection of law. So let us first proceed with the basic structure of Constitution. We should know what is the basic structure of Constitution. The sovereignty of India, the ideal of welfare state, secularism, federalism, rule of law, supremacy of the constitution, judicial review, independence of judiciary, separation of powers between the three organs of the state, balance between the FRs, means fundamental rights, and directive principles of the state policy, republican and parliamentary system. This is not fixed. It depends on the Supreme Court and it can add some more in the basic structure. Now we should know what is the significance of the basic structure of doctrine. The basic structure means those aspects or parts of the Constitution without which the Constitution would leave its original character. The basic structure of doctrine has helped in maintaining the supremacy of the Constitution. It has also shown a definite direction for the constitutional development to take place in country. The Chief Justice of India, Justice D.Y. Chandrachud, compared the basic structure of the Constitution to the North Star and the unfailing guide which shows the way when the path appears convoluted, means confused. In the Minerva Mills Limited versus Union of India case 1980, the Supreme Court upheld the basic structure of doctrine. So in a note we can say the Supreme Court in the J.R. Coelho case 2007 held that the laws added to Schedule 9 by amendments made after 24th April 1973, that is the date of the judgment of Keshwanand Bharati case, are subject to judicial review. The ninth schedule is subject to partial judicial review. As a summary, we can understand. Now we should know under what condition the fundamental rights can be suspended. There are certain articles which deals with it. Under Article 358, the enforcement of the fundamental rights under Article number 19 is automatically suspended if the national emergency is proclaimed on the grounds of war or external aggression. Under Article 359, the President, by the separate proclamation, can suspend the enforcement of all the fundamental rights except those mentioned under Article number 20 and 21. During the armed rebellion, fundamental rights are not suspended. Now we should know what are the classification of fundamental rights. There are 6 categories of fundamental rights. The first is right of equality, which comes under Article number 14 to 18. Right to freedom, Article 19 to 20. Right against exploitation, Article 23 and 24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, Article 29 and 30. Right to constitutional remedies, Article number 32. We are going to discuss one by one in the detail. First of all, we are going to discuss about the right to equality, Article number 14 to 18. The first article, Article number 14, provides for 2 types of equality. The first is equality before the law, and the second is equal protection of law. Now, first is the equality before law. It has been taken from UK Constitution and it means that no one is above the law. All are equal in the eyes of laws. Concept of equality before law is based on the concept of rule of law. Rule of law establishes supremacy of the law, that is lex supraemus, and which was propounded by Aristotle. This concept of rule of law was propounded by Greek philosopher Aristotle. He was of the view that the rule of law is better than rule of men. He was also of the view that law should govern and those who are in power should be the servants of law. In the absence of the written law, even a most honest magistrate can become dishonest. In the modern times, the concept of rule of law has been popularized by the English scholar Professor A.V. Dicey. Professor Dicey developed the principles or the postulates of rule of law. He talked about three aspects of rule of law. The first one is supremacy of law, second one equality before law, and the third one the predominance of the legal spirit. We are going to discuss these all in detail one by one. The very first is the supremacy of law. Every person should be governed by law. There must be absence of wide discretionary powers of the rulers so that they cannot make their own laws but must be governed according to the established laws. Now we are going to discuss equality before law. This principle emphasizes that everyone, whether a government servant as well as the non-official, should be administered adjusted by ordinary law codes. There should be equal subjection of all classes to the ordinary law of the land. Now we are going to discuss about the predominance of the legal spirit. According to Dicey, citizens are being guaranteed certain rights such as right to personal liberty and freedom from arrest by many of the constitutions. Only when such rights are popularly enforceable in the courts of law, those rights can be made available to the citizen. Now we should know what are the exceptions to the equality before law. First one, the president or the governor of the state is not answerable in a court of law for the administrative decisions taken by him. Second one, no criminal proceedings can be initiated against the president or the governor of the state during the term of their office. Third one, the foreign diplomats and the visiting foreign dignitaries are not to be punished in accordance with the law of country. It is known as diplomatic immunity. It is UN conventions that we have signed. Article number 14, the second part, is equal protection of law. This concept has been taken from the US Constitution. It means equality among the equals, like to be treated alike. Equality under equal circumstances. Article 15 is available only to the citizens. Article number 15 clause 1 prohibits the state from discriminating against any citizen only on the grounds of religion, race, caste, sex, or place of birth. So in a note we can understand the state not to discriminate against any citizen on the above mentioned grounds with regard to access to shops, public restaurants, hotels, and the places of public entertainment, or the use of wells, tanks, bathing areas, roads, and the places of public resort maintained wholly or partly out of the state funds or dedicated to the use of general public, as per the article number 15 clause 2. Now there are some exceptions to the article number 15 also, which are the article number 15 clause 3, special provisions can be made for children and the women. Article number 15 clause 4, special provision can be made for the socially and educationally backward classes, including the SCs and STs. It was added by the First Amendment Act 1951. Article number 15, Clause 5, reservation in educational institutions for socially and educationally backward classes. It will include scheduled caste and scheduled tribe. It was added by 93rd Amendment Act 2005. Article number 15, which is having two subclauses. Article number 15, Clause 6, Subclause A. It provides for special provisions for economically weaker section of the citizen other than the classes. And the Article 15, Clause 6, Subclause B provide provisions can be made for any economical weaker section of citizen relating to their admission to educational institution is whether aided or unaided by the state other than minority educational institution. In a note we can understand Article 15, Clause 6, Subclause B. In case of reservation, it would be in addition to the existing reservation and subject to a maximum of 10% of the total seats in each category. By this, I'm going to conclude the video for today. Thank you.